All right. Um, our next speaker is Tamara Pow. Tamara is, in addition to being an attorney, Tamara also has an MBA and she also has her LLM in tax. She's a founding partner of Strategy Law. She advises business owners and real estate investors on business transactions, including contract negotiation, liability protection, and entity planning. Tamara has extensive experience with the formation and representation of corporations, LLCs, LLPs, general partnerships, and limited partnerships. She handles 1031 exchange tax planning and other commercial real estate matters, including purchase and sale agreements, due diligence reviews, and leases. Tamara is also a successful business owner in her own right. Strategy Law is a 10 plus attorney law firm based in Silicon Valley. It's my pleasure to welcome to the Law Firm Growth Conference, Tamara Powell. Let's see. I saw her here earlier. There she is. Hang on a second. All right, Tamara, we just made you a panelist. Can you hear me? No? All right, let's do this again.
There we go. Thank you
There
for,
you are.
yeah, sorry, I wasn't on as a panelist, so I wasn't able to share my screen initially. But thank you
You're
for
all set.
that. And thank you for including me today here. I'm going to put up some slides of my own that I hope you guys can all see. And
Yep, we can see him.
okay, so today is about less stress. I want to be very clear that when that comes to partnerships, they don't often go together. Stress often comes with being partners. And so my goal today is to talk to you about what you can do in your law firm partnership agreements and how you process your partnership in order to, as much as possible, avoid stress later or throughout your partnership. So let me start by saying I have been managing partner of two firms. And my current firm, I have grown from initially 3 partners to we're now 8 partners. And that included going through a merger where we added 3 partners at once this year, which is definitely a stressful point for any firm. And so this is something near and dear to my heart. So I want to talk about first the fact that partnering up is, it doesn't necessarily mean less risk. So first of all, just for fun, so we know who we're dealing with, go ahead and put in the chat, if you are a part of a partnership, how many partners you have. So put 0 if you're a solo, and maybe put a plus if you're considering partnership, but otherwise put the number of partners you have, because it would be really interesting to kind of see who we're dealing with and what the issues are for everybody. All right, so with that, partnering up can mean synergy. It can mean spreading risk. It can mean collaboration. It can mean doubling possibly your odds of success. It can mean economies of scale, but it doesn't necessarily mean less risk. Partnering can be very difficult. So I really encourage you to consider whether you have to partner up. You can instead get a lot of those same benefits by just sharing office space or by being of counsel or even employees to each other. So before you take this plunge, I want you to think about this photo. It really is like a marriage in many ways. And you know how many marriages go bad. I think law firm partnerships would probably outweigh that percentage. But you're sharing income. You're sharing a bank account. You're sharing retirement accounts. You get a place together. You furnish it. You have dependents. You have to agree on big things, and you have to let little things go if you want to stay happy in a partnership. But there are some things that aren't like a marriage. It's not, it doesn't involve love usually, no sex, hopefully, and no vows. So, I've dealt with partnerships that over time have come back to me. And one of them, I remember the partner coming back to me and saying, look, you told us this was going to be like a marriage when the two of us started this law firm partnership, but you never told us that I would have a duty to support. That's not what I signed up for. And in that case, one of the partners just happened to be doing a lot better than the other and was starting to feel the resentment. So they started out as best friends, and I'll talk about their situation a little bit more, but that friendship landed up going away when the partnership went away. So you need to think carefully about not just whether or not to partner up, but who to partner up with. So get a prenup. That's the equivalent here of a prenup is your partnership agreement. And before you just jump into any partnership, or just like before you would jump into any marriage, you need to make sure you date that person. You need to ask them about their future and their plans and what they see as their goals. Because if you don't, the partnership is doomed from the beginning. So I'd say that lawyers are notoriously bad business people. I learned that when I was actually a very young lawyer. My first job, and actually before I was even a lawyer, I learned it. I was working for somebody during law school, and she was the worst business person I'd ever seen. And I started working for a different attorney, and he was also a terrible business person. These were both solos. So when I started law school, I was determined not to be like them. And I actually added the joint MBA program to my education because I thought that was so important to understand how to operate your business. And that's a big part of what you're learning here today and out of these 3 days is to stop and think about your law firm, not just practice law, but plan as if it is a business, because it is. So before you partner up, you want to make sure that your visions align. You want to make sure that there are benefits to being partners with each other. Maybe your areas of practice are separate so that you can collaborate on projects and each put in your share, or maybe you back each other up doing the same type of law, but make sure you understand where the benefits there are. I had a friend years ago who always dated women based on how attractive they were, and then always broke up with them based on how, well, I won't say how stupid, but based on their lack of intelligence. And I remember sitting down with him someday and thinking, have you ever considered dating people that you find attractive based on their intelligence? Because you're looking for one thing and it's not what you really need. So law firms, what does that mean? It means a strategic plan. You really need to sit down either in your current partnership, if you don't already have this in place, or before you go into a partnership, and talk about both the long-term plan and the short-term plan. So what is your mission? What are your values? What is your vision for the firm today, 3 years from now, 5 years from now, 10 years from now, when you retire? And then from there, take your time, figure out your goals, make sure those goals are SMART goals, they're precise, they're measurable, and you know how to get there. And then come up with the strategies and tactics for what you're going to do, the steps you're going to take to get to those goals. And I highly recommend, there's a book called The E-Myth. E stands for entrepreneur, and it's by Michael Gerber. There's also the E-Myth for attorneys, but which is great if you're a solo or really starting out. But the E-Myth Revisited is his main book, and it talked about before you get into a partnership or start a company, you want to build an org chart. Build it out, write it down with a box for every position, and then put somebody's name in every box. So initially, if you're a solo, that might be your name in every single box, and that's fine. If you're partners, it might be you get that opportunity to decide who's in charge of HR, who's in charge of IT. And you go through each box like that so that you have a really good plan of who's responsible for what. And in the first law partnership I was in 19 years ago, this was a real turning point for us because we drew the org chart out. It was very clear whose name was in each box. I was great at marketing. He really loved technology. So we just clearly put our names in the boxes and had some fun doing it. And then there was one box up at the top that was just sitting there blank. And it was who the CEO or managing partner is. And I was afraid to fill it out. And I hesitated. And we looked at each other and he said, well, I think that one's obvious. And my stomach sunk for a minute because I thought, oh God, if he thinks he's managing partner, then we're going to have a problem here because that was my intention all along. That's why I did the MBA. I have all of these plans. And he looked at me and he said, that's clearly you. And it was such a great jumping off place for that partnership because we defined the roles early on. And that was very helpful to draft the partnership agreement and to do all of the things you have to do, which, as you all know, are significant in order to get the business going. So the last thing I'd say about planning and strategic plans is they cannot be static. You have to take that plan and you have to revisit it. You have to adjust it regularly. So review it, go back and adjust. And I'd say that's the same thing with any law firm partnership agreement. Partnership agreements, just like your strategic plan, are not static. So you need to calendar, whether it's part of your annual meeting or every couple of years, to go back and look at your partnership agreement, not just when some material change happens, and make sure that it still says what you need it to say. All right, most important, biggest mistake people make when they're getting into law partnerships with other people is just failing to limit their liability. And when I say that, I'm not just talking about malpractice insurance. I'm talking about all liabilities. So contracts, guarantees, loans, employment liabilities, ERISA liabilities, taxes, dealing with ethical matters, dealing with trust accounts, all of those things come into play. So for example, if you are signing a lease for your law firm, knowing upfront whether or not you're willing to sign a personal guarantee is critical. Knowing whether you alone are willing to sign or you're only willing to sign if all of your partners sign. And I'll tell you, I recently had the opportunity to do some expert witness work in a case where two attorneys were working together. They called themselves an LLP and they signed a lease as an LLP. And they thought that meant that if they shut down the LLP someday, there would be no personal liability for them and they could just get out of this lease. But they didn't treat the LLP, limited liability partnership, correctly. And as a result, the court held that the LLP was not properly structured and treated, and they pierced the veil and went after the individual partners, but really only the one who had signed the lease, and had made some misrepresentations to the landlord about the fact that they were really practicing in this LLP the way you would expect. And that attorney ended up being on the hook for over $1 million worth of outstanding rent on the remainder of that office lease term, as well as attorney's fees for the landlord. So not only do you need to think about all of these different things and have insurance, but you need to plan carefully and make sure that you talk with your partners about those liabilities and about things like indemnifications. So that in that case, when he's held fully liable for the rest of the lease term, unless he has a contractual right to go after his partners for their share, it's all on him. And so definitely thinking about liability up front. Now, with that in mind, choosing the appropriate entity type. If you just decide to start doing work for each other or with each other or helping each other with clients, or if you just put out that we're working together, you and whoever that other person are could be held liable for each other as just a general partnership. So the tax law, for instance, says that if Alay and I were to go out and put a lemonade stand on the corner and start selling lemonade, and we make more than $600, bring in more than 600. Now we've got a partnership and we're required to report for taxes as a partnership, as well as we're responsible for anything that happens there personally. Even if I'm not the one who did anything wrong, I would be responsible because it happened in that general partnership. So you really want to think about forming the right kind of entity for your law firm. And that's a big part of what you need to know before you go into the partnership agreement drafting, of course. So in California, what are our choices? Obviously, sole proprietorship, the general partnership I just talked about, professional corporations, and that could be either treated as a professional corporation for tax purposes or as an S corporation for tax purposes. So you want to make sure you get good tax advice if you do form a corporation, or a limited liability partnership, which is the most flexible type of law firm entity. It falls under the General Partnership Act, but it gives you liability protection for the malpractice of your partners. Or again, as I said at the beginning, partnerships are difficult. You don't have to form a partnership. You can do an office share. You can do referral fees. You can be independent contractors for each other, or even an employee that's on kind of an eat what you kill percentage-based pay. So there are lots of opportunities to structure the entity in ways other than just simply getting together and forming a partnership. So keep that in mind before you get started. All right. Biggest and worst mistake I've seen with partnership agreements is simply just not having one. And you'd be shocked how many lawyers don't have partnership agreements. It's one of those things that we hear, like the plumber's house always leaks. Make sure you have a signed agreement. Do it now, not later. I've worked with many attorneys that get so bogged down in the details that they never get the agreement signed. And I always tell them, done is better than perfect. Get a partnership agreement done, and you can always schedule to restate it or just amend it once you get up and running and can work out some of those details. So I think that's critical. I had one partnership I worked with that said, look, we'll finish this when we've got more money and more time. Right now, we just need help with some basic contracts to get the law firm going, and help us with our lease, things like that. We'll come back to you with the partnership agreement. Well, fast forward a couple of years, they never came back, and one of the partners died. And then they were dealing with the complete mess that comes with having to buy out a partner's spouse after death in an ongoing partnership. So you're dealing with your partner's death, you're dealing with having to run the firm, and now you're dealing with the spouse claiming, well, half this partnership is really valuable, and I think you owe me $1 million. And that's an incredibly painful situation to be in. Even if that buy-sell or the valuation hadn't been perfect, it would have been some rules that they could have followed in that situation. So the other thing I didn't mention up front is I have been managing partner of 2 law firms. One of them, I was very fortunate that I had drafted the partnership agreement, because after 9 years, I was no longer wanting to be partners with that person, and I had to trigger the buy-sell that was in our agreement. Going through a partnership breakup, and in my case, it turned out to be something that went all the way to litigation. It gave me a level of experience that, essentially I've been to the dark side and survived. It made me a much better advisor. It made me much better for my clients when I'm talking to them about the what ifs of partnership agreements and what can go wrong. So get qualified counsel with real experience. Somebody who isn't dabbling in doing law firm partnership agreements, but actually has done many and knows what else is out there and knows what happens, when partnerships dissolve, and not just when everybody's happy on the front end. As I've already mentioned, revisit them, amend them, and then make sure you've got all the right provisions in there. So just a side note, if you're forming a corporation, instead of being a partnership agreement, it's called a shareholder agreement, but all of these provisions that we're talking about still apply. Inadequate capitalization. That's a big one. All partners should have some money on the line. You all need to have some skin in the game. So if you sign guarantees, as I mentioned earlier, make sure all of the partners sign them, or at least all of the managing partners, or the majority partner if it's an extreme majority. My advice is don't use credit, especially for draws. If you get a line of credit and you need that initially to survive, or if you're a contingency fee type firm, just make sure that you don't get used to paying yourself by credit, because that gets incredibly expensive and it creates a lot of problems when you go to wanting to dissolve the entity or separate from your partners, or just dealing with partners' unrealistic expectations of cash flow to begin with. So if you have to take a draw through a line of credit, or if you need a line of credit up front, make sure to try to pay it off as soon as possible. And don't loan funds for initial capital contributions when you're just starting out with a partnership. If you're mentoring a younger attorney that's eventually coming in and joining you as a partner, that's fine to loan them some funds or let them contribute over time. But make sure that you get the adequate security you need, so that if they don't pay or if things don't work out, you can simply remove them from that partnership. And then plan for your cash flow. Keep reserves. Don't take out all of the funds every single month if you can help it. You really need to keep in mind that partners don't like putting money into a law firm. And so the only way to prevent that is with distributions. Don't take out more distributions than are necessary. The saying goes that the top 3 arguments in any law firm are about money, money, and money. It manifests as arguments over small issues, but it all boils down to money. So get sound financial information in real time. Profits and losses are different than distributions. Profits and losses are how much the law firm made and how much the partners are going to pay tax on, but it doesn't mean you have to distribute out all of those profits. Be very careful with how you structure distributions. I highly recommend against 50-50 ownership. It causes much more disputes later and arguments. Also be careful with subjective assessments of deciding how much everybody deserves. If you're going to do that, you might want to have it part subjective and part objective, which is, have a formula for each partner gets paid based on what they've brought in, the eat what you kill concept, or based on a percentage of revenue, or some unique combination of this, because every law firm is different. Next, make sure you consider management. We talked about the organizational chart. Somebody has to lead the firm. Working with other lawyers does not require sharing all decisions. But you also need to figure out who your successors are, how you're going to deal with deadlocks, which I recommend you don't have. Like I said, 50-50 is always problematic over time. But if you do have that, or if you do have unanimous votes, make sure you know how you're going to get out of them. And then, as I mentioned earlier, revisit with firm growth. Disagreements come up. You might need a veto. You might need terms in the partnership agreement to deal with bad behavior. Have the right to expel a partner that isn't doing what they should, or that you just can't stand working with anymore, or doesn't meet your mission anymore. Consider having a confidentiality clause in your partnership agreement. Mediation, arbitration, you want to avoid airing your dirty laundry if it goes there, and minimize your reputational damage at the back end of a partnership. And also, of course, consider an attorney's fees clause. Buy-sell terms are good. They're not as strong in a law firm partnership, because obviously you can't sell to a non-lawyer. So selling partnership interest is limited, but you want to make that very clear in your partnership agreement, how you can transfer, when you can bring in additional partners and who has to agree, what happens on massive life-changing events like death, disability, divorce, retirement. Are the payment amounts different if you retire versus if you leave the firm to go compete? And do you get time to pay? Does the law firm have time to pay the partner who's leaving so that it doesn't bankrupt the law firm? And finally, lawyers are really naturally competitive, and they tend to blame other people rather than themselves, which distracts from their success. So make sure that if you have that up front, you consider that this could land up being a bad partnership and have a plan to unwind or dissolve. Put the details in there. So, for example, you know, the I had one partnership that had to deal with somebody who landed up in the January 6th insurrection and was posting on Facebook, and it became incredibly embarrassing for the firm, and they needed to be able to trigger something in the partnership agreement to get that partner out. Those are things that they were very thankful were drafted into their agreement. And consider owning your own web page, phone number, email, or blogs, or things like that if there's just two of you starting a partnership together, so that it's easier to dissolve on the back end if you're starting a new small partnership. And then finally, I just want to mention quickly, there are state bar regulations that are required, both initially, annually, and then if there are changes. So make sure you are registered with the state bar and that you update that. So that's a ton of information about partnerships. As I mentioned, I really recommend you reach out to somebody who is experienced in that area and talk to other lawyers that you know that have been in partnerships about their issues and what's gone right as well as what's gone wrong, so that you can best plan and get the best starting partnership agreement you can, or possibly decide that it may be less stress for you not to be in a partnership. And I'm available if anyone has questions. I don't know how much time we have.
We have a few minutes, so if anyone has questions for Tamara, I think she can probably answer one, maybe two questions. While you're thinking about putting those in the chat, just really quickly want to share that I've worked with Tamara. She was incredibly helpful for getting my partnership off the ground. And that was an awesome experience. A lot of these questions, it may seem overwhelming. You may not even know what those questions are. And that's where having an attorney that knows what they're about, like Tamara, can walk you through those questions and help you come up with the answers that are going to work for you. All right, questions in the chat. Okay. Tamara, I'm not sure if they are really delighted or just totally overwhelmed, but that was
I
fantastic.
answered
Thank you.
everything. Yeah.
You did. We do have one question that came through. Are there personality profile tests that can help determine if a partner is going to be good to work with?
I'm sure there are, and Alay, you can probably answer that as the coaching side as well. What's available? One thing I have found useful was the Now Discover Your Strengths book, the Strengths Finder. And it wasn't that certain personalities are better, it was really how to manage other personalities. So, for example, it taught me that my former partner really liked to focus on the negatives and what was going wrong. And I liked to focus on the positives and what was going right and how we could capitalize on those things. And so that's where one of our conflicts was coming from. And it was a good opportunity to step back and kind of look at how we manage the relationship and dealing with each other.
Awesome. And yeah, building on that, there are many, many personality assessments that can all be useful. There's, as far as I know, not a single personality assessment that you can just take in isolation and we'll say, yep, we're a good fit. Because as it turns out, personality types, which may not have a lot of conflict, that might actually be a problem for your firm. So you want to have a little bit of conflict, maybe, but not too much, and it just kind of depends. So, but they are really, really helpful, and I've used them many, many times in these kinds of situations. Question came through: what percentage of partnerships end in divorce?
I don't have that statistic. Paul could tell us what the percentage of actual divorces is, but in law firms, so when I started my career, I was working with one lawyer who came to me and said, I need you to break up this law firm partnership between me and my partner and form a new one. And I did. And 6 months later, he said, nope, that didn't work out. I need you to break that one up and form a new one. And I said, no, I'm going to make you a PC by yourself, and you can contract with this person. And I actually made him a deal that I would go ahead and do the partnership agreement for free if he landed up staying as a partner with that guy for a year, and he didn't. So I would say I've seen quite a lot break up over the years.
Awesome. You're getting some reactions too, which is really cool. Tamara, thank you so much for joining us today. A ton of great information. Really appreciate your time.